Hello, everybody. Look who's back in. We are going to do, whoopsies, the pumpkin and cinnamon bars tonight. I think we'll make an egg and cheese ones for breakfast. These are more like dessert. They even smell good. It's weird for a dog treat to smell good. And no, I am not tasting one. Ava tastes plenty. She says they're good. And they're good for her because the bag says so. She loves Blue Buffalo. My goodness. Oh, and of course, here comes the train. Oh, baby girl. Oh, I took out only one. I'm so sorry. Hey, let's see. Can you out train the train? Say, woof. Good girl. Sorry. Nana Laura, it'll be coming your way in 1 hour. Hello, C-Rex. Good to see you, sweet love. Hello, Nana Laura. Hello, Manuel. Hello, Sandy Hurd. Yeah, I'm sorry. That was my bad. It got extended. It was a combination of me procrastinating and then Ava having to potty at the last minute. Hello, Jerry Matthew Boyd. Hey, Joey Bag of Donuts. Donuts. Joey Bag of Donuts. Donuts. Hello, I'm Nene Carlin. You guys are so great showing up for me every night. I know you're here for Ava and Earl. Ooh, where did Earl go? Earl was just there a second ago. Oh, wow. He's quick. Oh, let's see here. We are sort of. The case is still exporting, but it's at like 72%. It's almost there. It'll get there. Hey, baby girl. Ups. Show everybody your purty face. Hello, Spider-Man, honey. Fried possum fat, squirrel, stew, pickled pig's feet, grits, and chitlins. That is one hell of a southern smorgasbord. It sounds like you're in, I don't know where, Louisiana? Mississippi? Ooh. I don't have my coffee. You're going to spill the tea and I don't have the tea to drink. What? I love me some red beans and rice. Okay, so you all know I love to cook. And red beans and rice is something that I can do. Everything that I make is Southern home cooking. Like my biscuits and gravy. Yeah, oh man. I make my mac and cheese from scratch. Like you name it. I've not actually, but Papa Henry, he grew up on chitlins. And when he was alive, he wanted chitlins so bad. I called every butcher, every one of them, asking if I could purchase the intestine. And no, they said it was a biohazard. They couldn't sell it to me because of risk and blah, blah, blah. So I tried really hard. And at that time, they were not available in the store. So unfortunately, Papa Henry passed away without me being able to make him homemade chitlins. But I definitely put in some effort. I really did. I was gonna. I don't think that's the news. I would be willing to put $1 down on that. On this day in 1998, my late husband and I got married. Oh, happy anniversary. Second, a friend of mine and I are planning a trip to Houston. You're going to go see Judge Fleischer. I know it. I know it. That is so great. I am so happy for you. I know how much you enjoy watching him. That is so great. Is there a third? We got first, we got second. Do we get a third? Ah! I knew I did. I knew it. I'm so happy for you. Everyone is. That's like a dream come true for you. You'll have to get pictures. I would love to see pictures with you and Judge Fleischer. That's all right. That's enough. That is enough good news. That is spectacular news. You guys are the coolest. I love being able to live through you. I get to share in all of your good times and your triumphs and, and when we need to, we shed some tears together. And yeah, I just love being a part of your guys' lives. Hello, Linda Applegate, my absolutely beautiful, wonderful friend. It is so good to see you. So tonight, guys, we are going to go spend some more time in Connecticut. Yep. Palmy, did you hear that? Palmy, where you at? We're coming to see you tonight. Yeah. We just have to, because this guy, he literally, he made me just bust out laughing. Some of the stuff that he says. I mean, it's not like overly excited, and he's not a soft set. He's just a pro se, but he's fun. He's fun. And the judge is so patient. Like, this judge is tasked with handling all of the pro se inmate motions and stuff. So the judge is very patient because he's treating them as if they're, still innocent, pending the outcome of whatever the motions they're filing is. So he treats them very respectfully. And, I applaud him. I don't know that I would have the same restraint. I'd be like, you were convicted. No, probably not. I mean, I'm sure you have to have certain level of decorum and demeanor in that position, and the judge, he plays that role perfectly. This is so much fun. This is so much fun. All right, let me.
Good morning. Can we open court?
Yes. Good morning, Your Honor.
Good morning.
Yes, Your Honor. The Superior Court for the Hartford Judicial District is now open and in session. The Honorable Carl J. Schuman presiding. Good morning, Your Honor.
Good morning. This is the matter of Ronald Smith versus State of Connecticut. Mr. Smith, I see you. Can you see and hear me?
Yes, sir.
All right. Good morning, sir.
Good morning, sir.
And appearance for the respondent, State of Connecticut?
Good morning, Your Honor. Attorney Kelly Davis. I'm here for Attorney Mariani, who has COVID and could not be here today.
Oh, I'm sorry to hear that. But
Yeah, he was going to try to log on anyways, but he's really sick.
oh, that's too bad. But good morning, Ms. Davis.
Morning.
I set up this hearing really more as a conference than as a hearing, just to discuss some of the issues that are out there and that I think also exist, try to get some clarification on a couple issues. So
Sure.
we're not really so much in a argument mode as a conference mode. So, Mr. Smith, I wanted to start with you. You filed a request to amend third petition for new trial dated August 27th. Do you have that in front of you?
Yes, sir.
Good. So I read it and I was honestly unclear what you're claiming in several respects. In particular, I was unclear whether you're claiming fraudulent concealment or newly discovered forensic science evidence, or both. So could you attempt to clarify?
All right. So as to the Third Amendment petition,
Yes.
it clearly states DNA evidence pursuant to General Statute 52-582A. The reason for that is because at the last hearing, Your Honor informed me and Mr. Mariani that 52-582B1 is for forensic scientific new technique. My claim been based on DNA evidence, 52-582A, except that I was quoting B1 as reference to the analysis done on the DNA evidence that was submitted at my trial via the documents that I submitted as my evidence 1 through 13 or 14, I believe. 1 and 2 is forensic documents. Where they at? Let me get them so I can be specific. Do the court have my packet that I sent in with the amendment?
I don't have the complete packet. I have some samples that Mr. Mariani sent me, but I was hoping you could answer my question as to whether you're claiming essentially as an exception to the statute of limitations,
DNA evidence.
Fraudulent concealment or newly discovered forensic science evidence, or both.
I'm claiming 52-582A, newly discovered DNA evidence.
So, I mean, that's not a specific exception to the statute of limitations, which we all know is an issue here.
There is no statute of limitations for DNA.
All right, let me see what you're referring to. The petition for new trial based on DNA, or I see, or other newly discovered evidence.
Correct.
That
statute encompasses DNA and forensic scientific evidence.
All right. And then it goes on, that was not discoverable or available at the time of the original trial.
Correct.
Okay, so you're focusing on that language.
Part A. Part A and B, but mainly Part A.
Yeah. And you claim there was DNA evidence that was not discoverable or available at the time of the original trial.
Correct, because if I can help clarify, there was misleading DNA evidence at my trial that was submitted. The testimony of Dr. Nina Livingston, who clearly stated that the victim DC tested positive for HSV infection. The DNA evidence that I'm referring to is test results, documents stating negative test results of DNA evidence of HSV.
HSV, as referred to in the context here, is the herpes simplex virus.
Right. When I read your third proposed petition for new trial,
I think I tried to clearly state that.
well, I didn't feel that way.
Right.
And that's one reason why I called this conference. But I read paragraph 12 and thought you're claiming fraudulent concealment.
Well,
yeah, go ahead.
Paragraph 12, let me get it out, sir.
Yeah.
Here it goes. Paragraph 12 states that after Smith's conviction in the state court proceeding giving rise to this petition, the petitioner discovered that the defendant engaged in a deliberate deception of the truth-seeking process. That's one of the claims, but it's not stating fraudulent concealment. It's just stating that they deliberately deceived the truth-seeking process by submitting false and misleading evidence.
I see. So you're not claiming fraudulent concealment as an exception to the statute of limitations.
Well, this part right here is not basically claiming that, because I believe that I would have to plead that, and I think that was addressed in the first petition for a new trial with Judge Noble, and
Right.
They already ruled that I couldn't get that anyway because, number one, I failed to plead it. Number two, I didn't meet the standard, so that's not in there. So,
Okay, you say this paragraph doesn't allege fraudulent concealment, and I gather from your additional remarks that you're not alleging fraudulent concealment as in any paragraph as an exception to the statute of limitations.
well, I don't think I can because I failed to plead it, Your Honor, from the original petition, because I think you're trying to well, maybe the state, or that we trying to go back to the how do you term it? If I could find it, the term revert back, I believe the term is something like that.
Sure, yeah, that phrase makes sense.
Right. Now,
well, whatever the reason, I just want to try to be clear that you're not alleging fraudulent concealment as an exception to the statute of limitations.
well, I'm alleging everything, Your Honor, but mainly.
Well, so are you or are you not alleging fraudulent concealment as an exception to the statute of limitations?
Can I say this, Your Honor?
Yeah.
What I'm claiming is two-part. That 52-582A, not B1A.
Right.
DNA evidence.
Right. I understand that part.
Right. In addition to the deliberate deception of the truth-seeking process. But I don't believe that I can get that at this time because this is the third petition.
Right.
So I don't know.
I understand some of the reasons, but I'm just not clear on your bottom line here. Are you or are you not alleging fraudulent concealment as an exception?
Yes.
You are alleging.
Yes.
You are alleging.
52-582A and that. Correct. Okay.
Okay.
Yes.
So you are alleging fraudulent concealment. Okay.
Yes, I'm alleging two parts, Your Honor.
Right. Fraudulent concealment is one part.
No,
and
52-582A is one part.
Right. What's the other part?
The one you just quoted, fraudulent concealment.
Fraudulent concealment. Okay. Yes. All right.
Get me into a bind, then that's what it is.
Well, I just want, because you have proposed to amend the complaint and the respondent and I both are unsure exactly what you're trying to do in the amendment. I want to try to clarify it so that the respondent can respond with a summary judgment motion or whatever appropriately, and so that we have define the issues, because right now I'm just unclear what you're saying in the new petition.
So you're unclear.
Go ahead.
So you're unclear about paragraph 1 and paragraph, I believe 4. That's unclear to you?
Well,
paragraph 1 and paragraph 4. That's unclear to you? of the Third Amendment petition.
Yeah. So 4 is fairly clear, but I was not clear as to whether you were alleging fraudulent concealment in paragraph 12 or not. And you're saying you are alleging fraudulent concealment.
If that's what you want to call it, correct. Correct.
Well, yeah, that's another exception to the statute of limitations.
Correct.
All right. And the
I
second,
didn't know that term could be used for that, but correct, Your Honor.
okay, all right, yeah. Okay, so what I'll eventually get to, and I want to discuss in this conference, is what documents you're relying on, but we'll come back to that. I just want to turn to Ms. Davis and ask whether you now understand the petitioner to be alleging fraudulent concealment and newly discovered DNA evidence as exceptions to the statute of limitations.
I do have that down. I'm going to get that to Attorney Mariani. So yes, Your Honor. I do see that those are his 2 claims.
Right, right.
Okay, thank you.
Okay, and if I allow the petitioner to file the new proposed amended petition, which I'm inclined to do, because I want to clarify the issues, and generally we take a liberal attitude towards amending petitions. Would you be inclined to file a motion for summary judgment based on the statute of limitations?
Yes, Your Honor.
Okay, all right. So now I kind of want to talk a little about the request for admissions and because the respondent and I felt it was a little unclear, and also what documents you are relying on, Mr. Smith, that show newly discovered DNA evidence. So, Mr. Smith, let's talk about that a little.
All right. With the packet that I sent for the amendment to the court was in one package. I had the amendment with the sealed envelope with the medical documents inserted in said petition that was attached. That was clearly marked trial, hearing, medical documents. So do you have that, sir?
I don't, but I don't normally get all the documents on a discovery request. So the question is, Ms. Davis, whether you have them.
May I just have a moment to look at Attorney Mariani's box? Thank you. I have it in front of me. It might take a second.
Okay. The last hearing, you asked me to send Mr. Mariani the documents I was going to refer to. So I sent it just roughly a couple weeks ago. This will probably be like my 5th time sending in the evidence. They should have like multiple duplicates of the evidence. But the recent one was when the court asked me to send Mariani exactly what I was talking to. And I sent Mariani and the court copies.
This is due process, guys. This is the tax dollars at work. This is him getting his fair shake. I don't know whether his allegations are true or not. I don't know whether he committed the crime. I don't even know what he's charged with. But this is what the courts have to do on a daily basis with the inmates after they're convicted.
Of the evidence that I was relying on.
So, Your Honor, I'm sorry to interrupt you. Did you want to say something first, Your Honor? Okay. So I have something dated August 15th, 2025, which we received on August 20th, I believe. It looks like it says enclosed redacted medical documents of DC pursuant to practice book. It's in the petitioner's handwriting. Then there's a sworn affidavit. It looks like there's an exhibit 1, plaintiff's exhibit 1, which is medical records, plaintiff's exhibit 2, a statement from the police, which is petitioner's exhibit 3. It's roughly like a 20-page document, Your Honor. I think this is what the defendant's referring to. There's notes from a child advocacy center. There's notes from a police hearing. I don't see a ton of medical records, but there's some.
Well, that's the main ones I was relying on because it's a stack. So it was so many. I sent in the ones that was referring to the DNA evidence. Exhibit 1, clearly marked Asylum Hill Family Medicine, 8/27/2003, lab report for wound culture provided by Fonda Gravino medical doctor, which states that they took a specimen of DC's wound where they testified that he had an open sore, which they tested positive for HSV. They took this wound culture and did a lab report on it, which gave a result of, if you could read it and understand it, it says that it could have been collected wrong, maybe not, transferred to lab, specimen at the bottom, rectal exam specimen. This is the one they took the DNA results that came from the HSV test. The second one is Exhibit 2, dated 10/29/2013, office visit, HSV, history, outbreak, lab reports, did the same test results was negative. So that's dated on 10/27. That's the DNA.
Yeah, I believe, sorry, I don't want to cut you off, sir.
No,
I
go
believe
ahead.
we have everything.
You two can talk to each other without going through me.
Thank you. I believe Mr. Smith did send us everything. I just didn't want to waste either Mr. Smith's time or your time going through everything, but he sent us a complete packet. I'm sure he sent this before, like he says. It's just the state's position is, I just want to make sure that this is what we're relying on when we're answering our motion. This is, or filing our motion for summary judgment. Are these the only documents that I'm using? Or the defendant, the petitioner's relying on?
Well, no, it's not totally, but these are the ones for the sake of the hearing right here.
Mm-hmm.
That's where the state finds issue, Your Honor.
Okay. Well, go ahead, Mr. Smith.
These are the DNA documents.
Yeah.
The other ones is medical reports with test results of a different variety. They may be used, they may not be used. But these definitely going to be used because these challenge the assessment, these medical documents that they have right now, challenge the assessment of Dr. Nina Livingston of DC testing positive, her test results about wound culture, her testimony about how they occurred, where she got it from, how she came to her analysis. This is what that's relying on. The other documents that I have, per se, they won't be of evidentiary value unless something else came up that was different outside the scope of this.
Mm-hmm.
So,
so, Mr. Smith, can you identify in particular what documents you have sent the respondent?
So his logic is that the wounds that were cultured, some of the wounds tested positive for HSV and some of the wounds didn't. And he is also calling into question the chain of custody of said samples. He's basically throwing wet spaghetti at the wall and seeing what sticks.
That show newly discovered DNA evidence.
Exhibit 1, 2, Exhibit 4, Exhibit 11.
Sorry, could we just slow down a little? Sorry, I'm writing when you're talking. So, no, it's okay. So number 1, 2,
1, 2, 4, 11, 13, the affidavit of chain of custody.
Is there a number for that one?
I believe, but I don't have it on this paper. It might be 14.
If I could just have a moment to check, sir, I can see.
Go ahead.
And I have another one that the state has, but I'm not sure. I didn't mark that one because I was saving that one because the state has it, but I didn't resend that in that package. But
So all I have is 1, 2, 4, 11, 13. I'm not seeing. What was the thing you were talking about, sir? The one after 13?
The affidavit for chain of custody by April Slade.
I don't see that.
That's been submitted. That was one of the ones he mentioned last time. That's in your custody. That I sent probably like 5 times. Because every time I send the evidence, I send that affidavit with it attached, stating how I
Your
got
Honor,
it.
And then, so 1, 2, 4, 11, 13, some affidavit of an April Slade, which I'll have to see if we have, but it's not, my understanding was this packet was supposed to contain everything that was going to be argued, Your Honor. And so I can look, it's just not in this packet. And
So
then I also just want to, go ahead.
Do you have April Slade affidavit?
I said no, it's not in this packet. So, Your Honor, there's also a final determination regarding a Russell Winiger. It's not numbered, but it says final determination. It's supposed to be a 7-page document. And we only have pages, the only pages that were submitted in this packet were 1 through 4 and then page 7. So we are missing pages 5 and 6. Just so the court, it's a document dated March 31st, 2014. It is a final determination regarding Russell Winiger. So we're missing 2 pages of that.
And Exhibit 8, do you have Exhibit 8?
I can check. Give me one moment, please. It is a follow-up child abuse consult that's redacted. Is that what you're referring to?
Yes.
It's a 1-page document? Okay.
Yes.
I have that.
Okay. Just making sure.
Thank you.
So the ones you don't have is Russell Winiger, page 8 and 9, I believe, 7, something.
No, 5 and 6 of 7. There's 7 total. We don't have 5 and 6.
All right. You don't have Ms. Slade's affidavit?
It's not in this packet, no.
Okay. That's noted.
Okay.
And so I assume I would have to send that in. And while I'm at it, I might as well send the rest of these documents, but I only sent them in because they pertain to the DNA, the 1 and 2, and 11, and for purposes of, and 13. You have 13?
Yes.
All right.
Let me ask this. I do have some of your requests for admission, Mr. Smith, because it was attached to respondents' response to request for admission. And so, for example, your first request for admission is Connecticut Children Medical Center. Do you admit that copies of medical documents received by Mr. Mariani are true and accurate? And your response, Ms. Davis, is denied. I'm wondering if there's something that we can clear up to so that you could admit that the documents are true and accurate, or what really is the reason you're denying that?
Sure, if you could just let me pull it up, because
Yes.
Attorney Mariani did this, so I'm kind of at a loss.
Yeah.
Is the court referring to, I have the judicial e-services pulled up. Is it 184?
No, 181 is the state's response to plaintiff's request for admission. And
perfect. And that's where Attorney Mariani hand wrote in it?
Well, so an attachment to that is a copy of plaintiff's request for admission. It's basically maybe the fourth page in that document is a copy of the plaintiff's request for admission. That's all I have from the plaintiff's request for admissions. But I see on page 1 of plaintiff's request for admission,
yep,
item number 1, CCMC is denied. And I'm wondering what the uncertainty is there that maybe we could clear up.
Yeah, I'm looking, Your Honor, I see exactly what you're looking at. I see Attorney Mariani wrote C state's filing of September 9th. So I just want to see what that is.
Yeah, let's look at that.
If the court has a line number for that, is that 184 or 185?
Let me go to the pleadings.
Thank you. I apologize.
No, that's all right. Go ahead.
Now I might be able to clear up.
Yeah.
Mr. Mariani sent a response in to my amendment. The second amendment. And I think he might be relying on the fact that he stated that he was denying the documents, number 1, because he didn't know what I was talking about. And 2, that the state should disregard and throw out said documents because I obtained documents illegally. So that's what might be the holdup. So that party did claim that the documents was received illegally. So they may not want to admit to them because they assuming that I'm not even supposed to have them.
So
that was his point.
Ms. Davis, I'm looking at 184. That's the state's objection to the petition's request to amend. So I don't think that's that relates to the request for admissions. 185, let's look at that. No, that's the state's position on summary judgment. I think the response to the request for admissions is 187. Matter of fact, no, that's request objection to subpoena.
That one I actually wrote. So
yes, you did. Right.
I understand that one.
Yeah. Okay. All right. How about 181 is what I read from. So I think those are the only responses to the request to admit.
I'm looking at bear with me, 183.
Okay. Oh, answer in special defense. No, that's what it sounds like. An answer in special defense to one of the petitions. So I don't really see anything in addition to 181 responding to the request for admission, but
I have it in front of me. It's dated August 19th, 2025.
Yeah.
The state response to plaintiff's request for admissions, dated August 19th, 2025.
Right. I have some of that. And I'm not requiring the state to admit.
Correct. Me neither. I mean,
to things. Yeah. Okay.
Because it seems like the state doesn't want to admit it. So I'm really past that because I can call the witnesses in and authenticate it through Dr. Fonda Gravino and Dr. Nina Livingston, and probably even the records keeper. I mean, so.
Yeah.
I understand the court's position. If the court wants, just because I don't want to speak for Attorney Mariani,
Okay.
I could see what he says about this and then I guess file something just so Mr. Smith can see what I'm saying, you know? I don't want to just email the court because I can't email Mr. Smith. So I could just file a notice or something.
All right. Well, here's what I'll ask is take a second look at the plaintiff's request for admission. All he's asking is that you admit that these are true and accurate copies. Although there's some language there that
I'm just referring to two doctors, Nina Livingston documents and Fonda Gravino. The other documents.
I could look at it, Your Honor.
Okay. And so, for example, you might be able to say as to one, that the state admits that these are true and accurate copies of the CCMC medical records. You might not admit to the way Mr. Smith characterizes it in the last line of paragraph 1, but you might.
I see what the court's saying.
Okay, good. So just take a second look at that.
Okay, and I'll talk to Attorney Mariani hopefully this week or early next week, and I'll get that filed as soon as possible.
Okay, let me ask you this, Ms. Davis. If I grant the petitioner's request to amend to allow him to file the third amended petition, you're entitled to respond, including by motion for summary judgment. When could you have that motion for summary judgment?
Do you mind if I just run to attorney, like one office down? I just want to look at Attorney Mariani's calendar.
Okay, I do not mind.
Thank you. I'll be right back.
Right.
Your Honor?
Yes, Mr. Smith.
I got a few housekeeping things. It appears that every time I send the court documents, they never get, like, per se, the medical documents, you never have them. I mean, I probably sent them like 3 times, Your Honor. I sent the package before, certified mail for the signature signed by the clerk on upon receipt. That never got there. Then the package I sent with the amendment, you say you don't have in front of you, correct?
Let's see. You mean the package you sent with the request to admit?
Right, but I sent the documents before that never got logged. Medical documents. It's like I just keep sending them and sending them in and sending them in.
Just my concern, Your Honor, and I know Mr. Smith, there's been multiple prosecutors on this matter. There's been a lot of people, a lot of issues, but our understanding was we were just going to get one document, one filing from Mr. Smith that has everything that he's going to use. And that's what I'm concerned about.
Yeah.
So
go ahead.
I can resend that. And I can send things I'm going to use, things I might use, things I think that because it's a stack of medical documents. So if the states want to see all of them, some of them are pertinent, some of them not. It might be 50 pages, I'm not sure, but I can send all of them.
All right. You do not have to send that to me, Mr. Smith, because normally on a request to admit, you just file something like a notice that you have filed a request to admit without all the attached documents.
Correct. Okay. I have done it. I sent the notice separately, but I just the medical documents for court's use, because last time we had the hearing, I remember you didn't have anything, but they had it, and it was that was summary judgment, I believe. You didn't have the medical documents.
But yeah, if you and I acknowledge that, and I've heard this from other prisoners that sometimes we don't get things that you have sent. But right now, I don't feel I need anything that that you've tried to send. I have the pleadings, and that's really all I need at this point. I assume, Ms. Davis, that coming back to summary judgment, that
Yes,
you will attach any records that you might argue don't meet the exceptions to this, that Mr. Smith might be relying on, that don't meet the criteria for an exception to the statute of limitations?
sure, yes.
Okay, all right. So I'll see him then.
Okay, just
actually,
back to, sorry.
yeah, back to
I
summary
was just gonna say
judgment.
yes, so Attorney Mariani is actually starting State versus Milner in Hartford. It's a homicide case on October 3rd.
Very familiar with that,
Okay,
as you
he's
may know.
starting it October 13th, I believe.
Oh,
That's when jury selection starts and evidence starts the 27th. So I don't know if the court wants to go after that. Attorney Mariani's the writer of this duo, so.
yeah. Well, October 13th is not far away.
Mm-mm.
It would be a lot to add, especially since he's sick. And it's
Yeah,
October
he's pretty
1st.
sick.
Yeah, I can't really ask you to file it before October 13th.
Thank you.
Yeah. It's just gonna delay things, but I mean, the petitioner has filed this new petition, and that in itself delays things. So, can let's see, the trial starts on October 27th.
Yes, Your Honor.
Right.
No,
So
the trial starts on November, Your Honor. I mean,
No, this is
Yeah.
a different trial, sir.
Oh,
Different
oh, oh.
trial, sir.
yeah,
Right.
so we're not gonna be able to meet that December trial dates, because with the new petition, the respondent is entitled to file a new response, which will be a summary judgment motion, and that's just going to set everything back. Okay. So I am familiar with the case, the Milner case. That'll take, and he is pro se, so that will take a couple weeks to try.
Yes.
So realistically, I'll suggest something like the end of November.
That's fine with the state. He doesn't look,
Okay.
his calendar looks clear after Milner.
Okay, so looking at the calendar, let's see. November 27th is Thanksgiving, 28th is the last working day in November. So can I say November 28th?
Sure.
Okay.
And I'll
November-
have counts. That should work. That'll work. Thank you.
Okay, all right. And again, it'd just be helpful if the state would attach as exhibits any documents that we're going to rely on, just because
Sure.
it's difficult for Mr. Smith sometimes to get a lot of documents to the court. Okay.
The state
Good.
can do it.
Okay, good. Mr. Smith, how long would it take you to respond to the state's motion for summary judgment? I'll give you whatever time you need.
I'm not sure. It depends on how long it is.
Okay.
I gotta
Do you-
be able to-
Yeah, do you want to wait until it's filed, and then we can set a scheduling order?
Yeah.
Okay, all right. So let's do that. We'll have another conference. And then maybe then we can set all the remaining dates to be set.
Okay.
So, let's see. Gonna give the mail a little time to get to deliver this summary judgment motion to Mr. Smith.
Okay.
And So I'll suggest December 8th at 10 a.m. for scheduling conference.
I'm sorry, may we go to like the 11th or the 12th? I'm out of the country, the 8th.
Yeah, except actually, so the 12th is open because I had it scheduled as a trial of this case, but that's
Okay.
not gonna happen. Scheduling conference at 10 a.m.
So they're basically turning his trial date into status conference and recycling the date. At least it's still getting used.
Sure, thank you.
Okay, all right. Final matter on the agenda is, Mr. Smith, I think all of your applications for subpoenas, and I know the state has objected to a subpoena for the victim. And I'm not going to act on any of these because the trial is not going to take place on December 12th. And so I don't want subpoenas to go out for a trial that's not going to take place at that time. I'll just add that with regard to the victim, my general approach on something like this would be to reserve decision on it until I've heard the rest of the evidence and see whether I think it's necessary to call the victim.
Yeah, don't drag the victim back in unless you have to. Please. They've already had to go through one trial. Well, 2 trials. And it sounds like the content of the trials was of a very sensitive nature. Don't make them relive it again.
I might say it is, I might say it's not, but I don't want to subpoena the victim until I determine that his testimony is necessary. So that's what you can kind of anticipate. You can, for the next scheduled trial, you can file all your applications and the state might file the same objection, and that's what I'll probably do. Okay?
Okay.
All right. So, again, I'm not going to act on your applications for subpoenas. Do you have copies of them with you, Mr. Smith?
No.
Oh, okay, because
I was waiting for the return of them.
I see. So, maybe just to save work on your part, I'll talk to the clerk, but maybe we can hold on to them. And if it comes to it, we can just change the date so that you don't have to redo them.
Correct. Is that like I think it's about 12 or 13, right? Something like that.
Here's what I have.
Because I sent 2 packages. That's
okay. Why. All right. I have, let's see, trying to see. Oh, this is application for waiver, subpoena for DC, the victim. Then, next is Michael Peck, trial counsel. Then next is State's Attorney Deborah Collins. By the way, she has left the State's Attorney's office. I don't know where she is. Kelly, Ms. Davis, do you know where she is?
I believe she's living in Florida.
That's what
is
I
the
heard.
last I heard.
Yeah, so that might be difficult. She might be difficult to get. Dr. Gravino, Fonda Gravino. Let's see.
Livingston.
Okay, Officer Winiger, Dr. Livingston, and
medical records.
Let's see, medical custodian of records, CCMC, Dr. Udo, St. Francis Hospital. So, I mean, I'm going through them, but it looks like I have all of them. Dr. Guerrera, Asylum Hill Family Medicine.
Correct.
Custodian of Records, Asylum Hill Family Medicine. I might have missed one, but I think I have most of them, so I'm going to
I think
hold
we
on
have
to them. I'm going to hold on to them for now. We'll see if you need them, and we'll try to find the easiest way of getting them out next time. Okay?
All right, so you would save them and possibly change the date.
Yeah. Yeah.
Okay, that sounds good.
Okay. I'll talk to the clerk about that.
Thank you.
So just to summarize, I'm going to put in an order here.
Okay.
And it's going to grant the request to amend the complaint based on the petitioner's statement that he is alleging fraudulent concealment and newly discovered or available DNA evidence as exceptions to the statute of limitations, but not other newly discovered forensic science evidence. Am I correct in that regard, Mr. Smith?
No, it's this the thing.
Yeah.
Last hearing, summary judgment, you informed me that forensic evidence claim, because I think I was construing them together because my DNA evidence is forensic evidence.
True.
So when I was quoting it, I was quoting B1, and B1 is new technique. So you were saying that's not correct anymore because this new case law Myers claims that, and I think I did read Myers, and I went back and read Myers, and it kind of says that it has to be a new technique. I would probably disagree with that because I think they was talking about new evidence. It couldn't be new evidence of any kind. My evidence is newly discovered forensic / DNA evidence.
Okay.
That's what it basically is. It encompasses the whole statute. 52-582A, 52-582B. You informed me B1 was for just a new technique. I was referring to B1 in the sense that because my evidence is DNA with forensic analysis that's totally different from other forensic analysis that was used at my trial.
Okay, so you
am I making sense? Am I making sense?
Yes, I follow what you're saying. You're saying your newly discovered forensic science evidence is DNA evidence.
Correct.
Okay.
Correct. And it was several different analyses done on the DNA with different outcomes.
Mm-hmm. And you have identified for us the exhibits that you're relying on to
and I
show.
have a few more that I'm going to send to the state since they want all. So I'm going to send everything.
All right. Well, I just so that we're framing the issues here, because this has been one of the difficulties in this case is that the issues keep shifting. I want to try to identify the documents you are relying upon to show that there's newly discovered DNA evidence, and you have listed these exhibits.
Correct.
1, 2, yeah. Are there any other exhibits that? Yeah.
Yes.
Just the 2 documents that are missing that we talked about?
Oh, it's 2 more, well, several more, but them the ones I was relying on for the hearing because it was so many. I used the ones that was available that the state was familiar with that I used from the beginning.
Well,
them was the ones I used. Them was the same documents I used from day 1 till now.
Yeah. Well, I'm trying to frame the issues because we've had difficulty with this, and identify the documents that you claim show newly discovered, we'll call it forensic science DNA evidence. And you have identified 5 or 6 exhibits. Are you saying now that there are additional exhibits that show newly discovered DNA evidence?
Correct.
What are they?
There are blood test results, wound culture results, transmitted disease test results from different types, positive, negative. At trial, they stated there was only 1, but these documents show that the victim tested positive for staph infection, tested positive for hepatitis, I think B, but they stated it was only HSV tested for. I have medical documents that state that the victim tested negative for HSV, that wound culture go ahead.
I'm trying to identify what exhibits you're relying on to show newly discovered forensic science / DNA evidence, so that the state. So let me just finish. Okay. So that the state can make its argument that this is not newly discovered. So would you please state the numbers of the exhibits so that the state can file a motion for summary judgment?
Well, I stated the ones just a little while ago. I believe I said 1, 2.
Right.
Let me get it out.
Right. I have it. It's 1, 2, 4, 11, 13, 8.
Right.
Correct?
Correct. And I have some additional.
Okay.
So my concern is the additional, Your Honor.
Yep, mine too.
And I will have them out in the mail because you gave them a date of December to respond.
Yeah.
Right? Correct. So I will have them out within a week, 2 weeks. So they will have.
Is the response date is November 28th, right? The last working day of November, right?
Yeah, but if the state doesn't have, if Mr. Smith has not supplied all the documents he's relying on for an exception to the statute of limitations, I'm going to give the state additional time until it has all the documents. I thought we went through this and identified the documents, but if there are more, then I don't think the state can start on the motion until it sees what the petitioner is relying on.
Correct.
Okay, the state agrees.
Okay, so when can you supply the additional documents you're relying on for an exception to the statute of limitations, Mr. Smith?
I can have them out in the mail by next week.
Okay.
No later than 2 weeks.
Okay, so I'll give you 2 weeks. Here's what I'll do. I will extend the state's deadline to December 5th.
Okay.
And we'll still have our conference on December 12th.
Okay.
So, Mr. Smith, just wondering what you could entitle this additional package that you're going to send the state. I mean, to me, it sounds like it's additional documents relied upon to or that show newly discovered DNA evidence.
Correct.
Okay, so could you put a cover sheet to that effect?
Okay.
All right. Okay. So I will enter an order granting the petition to amend the request to amend the petition based on the representation that the petitioner is relying on fraudulent concealment, and we'll call it newly discovered forensic science / DNA evidence within the meaning of the statute.
Can I?
And yeah.
You're putting the cart before the horse, it seems like. You're quoting line, what is that, 12 or 7, whatever, as the standard that I'm relying on. I'm relying on 1 and 4. Number 1 and 4. 52-582A. I'm relying on that with additional fraudulent concealment that you're quoting. You're quoting fraudulent concealment as the baseline, and I'm relying on the fact that I have newly discovered DNA evidence of a forensic nature.
Yeah, I understand that. We spent 5 minutes on the question of are you also alleging fraudulent concealment as an exception to the statute of limitations? And after 5 minutes, you said yes.
Correct. I said yes, but you starting off with is fraudulent concealment, then put it in.
Okay. All right.
That's not sitting right with me.
Okay, I'll reverse the order.
Right, because my basis of my petition states 52-582A, 270, 4255, paragraph 4, DNA evidence undiscoverable or available. Then as it get in, it goes to fraudulent concealment.
Okay.
So the baseline is DNA evidence.
Okay. All right. I'll reverse the order of those.
Thank you.
And give the state to December 5th to answer or respond to the petition. We'll have a scheduling conference on December 12th. I'll give Mr. Smith 2 weeks to supply additional documents he's relying upon to show newly discovered DNA evidence. And
isn't that all they ever do, though? Like, do you really think that most of these inmates that we watch, do you really think that they genuinely believe in their heart of hearts that they are going to reverse the decision of the courts or the decision of the jury? Or do you think this is just entertainment for them and a chance to be out of their cell and a chance to feel like they're accomplishing something? I don't know.
And I'll take no action on the applications for subpoenas at this time, but I will hold on to them.
Thank you.
Okay? So I think that summarizes what we've talked about and what I'll put into an order.
Okay.
Mr. Smith, is there anything else?
The screen froze for a second.
Yes. Oh, I'm sorry. So what's the last thing you heard from me?
You was I'm not sure.
Okay,
he froze again.
Really?
Yeah, he's frozen, I think.
Oh, jeez. Well, Mr. Smith, can you hear me now?
Yes, you
Okay.
were saying that you was going to hold a request for witnesses. That's the last thing I heard.
Yeah. Okay, that's basically all I said. At the risk of tempting fate here, I'm going to conclude the hearing and say I will enter a scheduling order today or by Friday that summarizes what we talked about today. Okay?
Thank you.
All right.
Thank you.
Thank you, Mr. Smith. Thank you, Ms. Davis. Have a good day, both of you, and we will stand in recess.
Thank you. Bye, everyone.
Court stands in recess. Thank you, everyone.
Thank you. Have a good day.
And now this guy, this guy's kind of fun. He has not mastered the art of the right to remain silent.
Okay. Now calling case numbers 21S00354 and 25S4483132. These are the State of Michigan versus Thomas Basher. Can I have appearances for the record, please?
Good morning, Your Honor. Assistant Public Defender Alexis Zerps on behalf of Mr. Basher in the new case that's scheduled for arraignment.
Okay, thank you. And Mr. Basher?
Mr. Basher.
Okay, thank you very much.
Yes,
So
Your Honor.
I am going to deal with this matter ending in 354 first. You were just set for a review of payment in this matter. So what I am going to do is set you for a new court date in that one. That will be July 17th at 9 in the morning. You have a balance of $437 in that matter. Okay, so that is what is going on with that one. Now, this new matter ending in 3132 is a citation that was issued February 5th of 2025 that charges that on or about that date, you operated a motor vehicle on westbound I-94 at or near Huron Street with an invalid operator's license. So either you didn't have one, you had multiple, it's a no ops ticket, okay? This is a misdemeanor. It has a maximum penalty of up to 90 days in jail, a $100 fine plus court costs, or both. Do you understand all of that?
Yes, Your Honor.
Okay, thank you. So, because this is a misdemeanor, you do have the right to remain silent. Anything that you say out loud or in writing can be used against you in court. You have the right to be presumed innocent beyond a reasonable doubt. You have the right to a trial by judge or by jury. You have the right to be represented by an attorney during all stages of these court proceedings, that is before, during, and after trial. You are not required to disclose citizenship status to the court, but you do have the right to consult with an attorney to see if this case would have any effect on your citizenship status. If that last part doesn't apply to you, then don't worry about it.
Okay.
Okay.
Can I ask what the one that you pushed to the side is about?
The other matter that I said you owe money on?
Yeah.
So that was the false pretenses case from 2021 initially. So that you already, let me see.
On the 12th, right?
So for, no, that's you have another matter that's a felony that's been charged as a felony that you have probable cause conferences set for. I'm not dealing with that one today.
Right,
Okay?
right. Yeah, that's the one that is concluding my conclusion today. Like I had a PR bond on it and he revoked it because of the driving ticket.
Okay.
Right, and because now he said that if I ended up coming to see whoever I was supposed to see on this driving ticket, and it was all okay, then he was going to reinstate my personal bond. I've been working for Home and New Vision, the treatment center, and all that, and I've been doing what I'm supposed to be doing, other than driving without a license. I guess.
Okay. So then, to be clear, the felony matter that you saw Judge Simpson on is something else. I wasn't talking about that one at all. The other matter that I talked about first was just that the old matter that you just owe money on, and then this one that you're being arraigned on. So, what I was going to do, because when I looked in the system, I saw that you had no bond ordered in the other matter, was set a nominal cash, a nominal cash surety bond in this, so that you'd get credit with the note on here that it's to convert to a personal recognizance bond if you're getting a personal recognizance bond in the other matters. So I may have to coordinate that a little bit with them.
Well,
Okay.
well, I mean, is it possible to just please get a regular personal bond on this matter, and then because I've already been to court and he told me that he would give me my personal bond back if I got a personal bond on this one.
Okay.
Your Honor, I did explain all of this to him. I did say that we could ask for that low cash bond to convert to the PR bond, but his preference is still the PR bond. He understands that with that bond, he would not be getting credit on this case while he is sitting until June 12th, but that's still what he wishes to ask for.
Okay. So
I mean, I'm doing everything.
Okay, and sir, I have.
Well, I'm missing my college. I started college on the 2nd of this month. I'm missing it. I'm missing everything for a card that I found on the side of the road. It's not even a case. They're gonna throw it out.
Just hold up a second. Okay, so Attorney Zerbst, have you had any communication with the attorney who handled the earlier probable cause conference?
Well, yeah, I've talked to him
Sir, just give me a minute, because that was actually, I'm trying to figure out what the public defender knows at this point. Okay.
Your Honor, I was looking at the notes in the file.
This is, I am proud of this man for his sobriety, for his dedication to the to serving the community through his sobriety by, going back to college. And it does sound like he's made a lot of positive changes in his life. However, what we are seeing here, I believe, is a little bit of some residual effects of his past life.
And it looks like there might have been a bond violation report for some kind of conduct.
I can tell you why. I can
Mr.
tell-
Vasher, don't say anything regarding the
Okay.
case, please.
I'm
Okay.
not worried about
So,
violating.
okay.
I'm not getting no wrong.
So, just so that I'm clear, it looks like you had a probable cause conference on May 29th, and then they've set you for another one for June 12th.
Yes, I had one for May 29th. I went and seen him, and they denied reinstating my personal bond. Here's what happened. I was reading. Can I tell you? You need it. You need to hear it.
Well, do you remember the part where you have a right to remain
Yes,
silent?
yes. I
Okay.
didn't do. I'm not going to
Mr.
say nothing that's
Vasher,
going
I
to
do
incriminate
recommend
me.
that you
I'm not
remain
going to say
silent.
nothing that's going to incriminate me.
Okay.
I was released. I've been out doing what I'm supposed to do. I was released to a treatment center. I did my treatment centers, did all the treatment center, started working for Home and New Vision, doing speeches for them. I had a personal bond on the case, which is a felony, which is stupid because I just picked up a card off the side of the road and put it in my pocket, and my wallet got lost or stolen. I had to order me a new card, and I had 2 bank cards in my pocket, and I tried my bank card to see which one was mine, put my stuff in, and voila, I had a.
Oh my gosh, like that is the worst luck ever. Can you imagine? I'm just strolling down the street and I see a card on the ground and I pick it up and I put it in my wallet because that's what you do. And then my wallet gets stolen, and I tested the bank card that I thought was mine, and it wasn't mine, and I got arrested. But they're going to throw that felony out of there. Oh my God. But I'm not going to say anything self-incriminating here.
Court date set on it. I missed the court date because my public defender called me and told me that we were getting it postponed for 21 days or whatever. So I didn't have to go tomorrow. So I called Marcus at Home and New Vision and said, hey, I can go do that speech for you today because I don't got to go to court tomorrow. So I missed it. So then that was my violation that sent me to revoked my PR bond. Do you see what I'm saying? So that put me back in jail, and now he refused to reinstate my PR bond because I had this matter.
Okay.
So if I got a PR bond on this matter, he was going to reinstate my PR bond on that one. So on the 12th, I can go home, go back to college, go back to work, and continue my good part of my life.
Okay.
That's just all it is.
Thank you. Okay. So what I am doing then with this matter, and let me finish before you say anything else. Okay, so you're being set for a pre-trial in front of Judge Washington in this matter. That will be July 17th as well. Okay. And
so
what
I don't got till then, right?
No. So what I am going to do is this.
Yes, ma'am.
I am making a specific note in here. At this time, you're getting a $1,000 10% bond.
Okay.
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 So that will enable you to get credit on this
Okay.
while you are
Okay, that's
sitting.
fine.
Okay.
That's fine.
And I have a note on here specifically. It will convert to a personal recognizance bond if you get a personal recognizance bond in your other matters. And if we need to communicate with 14A1 about that, we can do that.
Okay, so that means that if he does reinstate my personal bond,
then this turns into a personal recognizance bond too. Okay?
Yes.
Okay.
So it would revert, would it revert that day though, like on the 12th when I see him? Or would I have to come back and see you?
No, you wouldn't have to come back and see me for that. Okay?
So it would revert that day?
It should, yes.
Okay.
Yeah, and you've got the public defender's office can reach out. We can
Okay.
communicate.
Okay, that's
Okay.
all I'm
Okay,
thank
Okay.
you, Your Honor.
you're welcome. Attorney Zerbst, was there anything else?
Nothing further, Your Honor. Thank you.
Okay, so just to be clear, for these two 14B matters, that next date is July 17th, 9 a.m. over Zoom in front of the judge. Okay? And, it sounds like you are trying to get yourself back on the right track, so please keep moving in that direction, okay?
That's the way I'm going. I'm doing pretty good. I got a whole church team behind me and Home and New Vision, and I got a great support system.
Okay, good. Yeah, I know the Home and New Vision does good work, so, okay. Well, then your hearing is concluded. If you don't have any questions, you are free to go to the door and tell them that you're done.
Yes, Your Honor. Thank you and have a blessed day.
Okay, thank you, you too.
Jazz hands are an acceptable way to get the correctional officer's attention. So oh, you guys are gonna love this guy's defense. You're gonna love this guy's defense.
Now calling 24T00470. This is Ypsilanti Township versus Dave Bussell.
Yep, Dave Bustle here, Your Honor.
Okay, thank you. So today is the date and time set for an arraignment in this matter. And what I am seeing here, we did receive a bench warrant recall request back on March 17th. You were ordered to report to community corrections for drug and alcohol testing and to pick up a SoberLink device. And I had a note here that if you reported to community corrections by the close of business on March 30th, that we would recall the bench warrant. I, as far as I know, have not received any sort of notification from community corrections. And the bench warrant is still active currently.
News to me. I did not know anything about March 30th. Not at all. I found out about this warrant by calling my attorney on the week of the 10th before my 19th in March. I was told that if I went to the Ann Arbor or the Washtenaw County with this warrant, I would be immediately arrested. So Ms. Krell, my community case manager over there, said, don't come in, just wait for the next court date. So this is why I'm here now.
So when you were in front of me on February 5th,
yes,
I had ordered you to go to community corrections by the close of business on February 13th. And that did not happen. So the bench warrant for your arrest was issued on February 27th. What I am going to do is this. So you are in Monroe County?
Yes, I recently moved from my grandmother's house in Monroe to Ida.
Okay. So, and that's slightly further towards Ohio, correct?
Yes, it's south, yeah.
Yeah. Okay. So what I am going to tell you is this. You have until 4 p.m. on April 11th. That is Friday.
Hmm.
To get to community corrections for drug and alcohol testing and to pick up the SoberLink device. Once I receive word from community corrections that you are there, I will recall the bench warrant.
Got it.
The bench warrant is going to remain in place until you go to community corrections and pick up the SoberLink device and do the drug and alcohol testing like you were ordered to do. So I will make notes. We will do an updated order to community corrections. And this is a not infrequent occurrence, so they know to reach out and ask if they're supposed to take you into custody. Okay?
I'll be there.
Okay. At this time, the court will set a date and time for the pretrial conference. That will be May 14th. 2025. That will be at 9 in the morning over Zoom in front of Judge Washington. All of your bond conditions are still in effect, and as I stated, the bench warrant is continued right now. Once I receive word that you've gone to community corrections like you're supposed to do, then we can talk about recalling the bench warrant. All right?
Absolutely.
Okay. Any questions right now?
Nope.
Okay, thank you. Then you've got your next court date. You know what you're supposed to do. You are free to sign out.
Thank you, Your Honor.
Thank you.
Give me 1 second. I am typing something that I'm not posting. Hold on 1 second. Yeah, probably like that. Oh my gosh, I hope you guys enjoyed that tonight. That was so much fun. Oh, you had me rolling. My stomach hurts so bad. Jerry Matthew Boyd. I didn't know you had it in you. Some of those comments. Oh, nasty. I know it can, but only for people who are really, really curious. And on that note, guys, just because you were funny, you had me laughing. That's why. No. The case was nasty. He just played into it. Oh, you guys have been amazing as always, even though Mortimer Duke showed up a half hour late or so. It's all right. He makes up for it. Oh my goodness. Okay, guys. Thank you. Thank you. If you can't tell, I actually slept last night. Yep. 7 hours and 9 minutes. I needed it. I definitely needed it. After 3 days of only like an hour to an hour and a half of sleep, I was not okay. I was not okay, guys. Oh, and here you get neither. No. Oh my gosh, and Salty Buddha, thank you so much, sweetie. I love you. That comment was really appreciated. Oh, my hair. My hair. I gotta look good for the closing. I mean, it goes on the Replay Crew minis. I gotta entertain the masses. I love you guys so much. Be safe, be well, sleep sweet, and much love.